Okay, so we'll get started now. So just to introduce the panel today, so we've got a very exciting set of speakers for this panel, International Approaches with AI Governance and Scrutiny. So first up we'll have Professor Matteo Ortino from the University of Verona. And then we'll have Michael Sierra from the Hebrew University of Jerusalem. And then Dr. Anja Moje Pedersen from the University of Copenhagen. And then Dr. Chi Jack Ozimiri from the University of West London. Now, what we'll have is we'll have 15 minutes from each of the presenters, and then what we'll have is a commentary from the discussant, Dr. Anton Moshenko from the Australian National University, and then we'll have 20 minutes in this panel for questions and answers from the audience. So please do, whilst you're listening to the presentations this morning, keep track of your questions, and also if you want, we can also I'll monitor to see if any come in the messages too for the Q&A. But yeah, just keep note of those, and then we'll have a sort of a proper panel discussion towards the end. So what we'll do then is we'll get started. I'll invite Professor Matteo Ortino to share your slides, and you'll be talking today about European standards on AI, our fundamental rights in safe hands. So over to you, Professor Ortino.
Thank you very much. Well, good morning to everyone. Thank you for inviting me and to this very interesting set of presentations. Well, the issue that I want to talk about today is about trust. There is a lot of discussions also in legal documents about trust and trustworthiness of AI. So the underlying question is, can we trust AI? Can we trust the machine? Can we trust the process and the outcome? Is it reliable in terms of accuracy, in terms of safety, in terms of its ability not to violate human rights, fundamental rights? Before addressing this specific question, we need to underline that trust and trustworthiness is a systemic concept, meaning that we shouldn't look only at the machine itself, but trustworthiness is the result of a wide variety of factors. Like when we ask ourselves, is it safe to fly, to take a plane to go from A to B? We asking ourselves not only about the plane itself, but also the environment, the system in which the plane operates, which comprises people, the pilot, passengers as well, other planes, the weather, the objects in the sky, the drones, but also the coordination between authorities, laws and regulations, people that check the plane, etc. So the same logic must be applied to AI. It's not only the machine itself that we need to assess, but also the surrounding system. And as lawyers, we obviously focus on laws and regulations. Now, we can ask, in a limited time that we have, at least four questions. Can we trust the machine? Can we trust technical standards to govern, to regulate the way it is produced, the way it is used? Can we trust the bodies that make these technical standards? And can we trust more the political institutions that should supervise all these lawmaking or standard-making process? I didn't say this before, but I will focus on EU law and on the Artificial Intelligence Act, that it's a regulation that was adopted by the EU. But I think the same issues apply everywhere in any jurisdiction. The way the AI Act is conceived is that it provides the basic legislation governing AI systems, AI models, and then the legislator has entrusted the European standardization organizations to, in particular, to write the technical details to implement the legal rules. These technical standards, or harmonized standards as they are called, are not binding, are not formally binding, de facto are. If a firm complies with them, they trigger the presumption of conformity. So they are presumed to comply, or they are presumed to be compliant with the regulation. So let's start with the machine. Can we trust the machine? Can we trust AI, the outcome? Well, the answer that one should give, and is the same answer that one should give to all the four questions, in my opinion, is only partially. So the trust should be in place only to a certain extent. So basically, it's a no, really. Can you trust the machine? No, not fully. We cannot. It's not possible to give an exact number of the percentage of cases in which the AI gives the wrong answer. Because it again depends on a wide range of variables. But I will only mention a recent study carried out in last August. 10 leading AI tools were assessed in terms of their ability to distinguish between fake news and real facts. And on average, the tools, the AI, generative AI provided 35% of the times a wrong answer. So it repeated 35% a fake news. And ChatGPT particularly provided unreliable or fabricated answers in 40% of cases, because chatbots rely on unreliable sources or invent answers from scratch. Now, obviously, in other use cases, in other scenarios, the percentage is lower, and sometimes the percentage is higher. But we all know, even our own daily life, that hallucinations are not a rare event. So at least the first answer to the question is the trustworthiness is limited. Now, what about the technical standards? Is it the right tool, the right legal tool to govern, to regulate AI? So can we rely on these legal instruments to regulate AI? Well, the answer again is only to a certain extent. So not fully, not really, because what can be standardized is only a part of the case. The concrete circumstances of the application of AI in a use case can never be fully standardized. values such as fundamental rights, which include legal concept of fairness, of transparency, of explainability, may be standardizable only up to a certain point, because they cannot replace the value judgment when a risk materializes, which can only be carried out on a case-by-case basis.
So, sorry to interrupt, Professor Artin. I don't know if your slides have paused, but we're still on slide 3. I just wondered if maybe it seems to have come out of presenter mode. It was just to let you know.
Okay.
There we go. That's moving.
Okay. So the third question is, can we trust the stamp-making body? And this is the main question that I address in my paper. These bodies are private regulators, and because they are private organizations and they are dominated by the industry. They are mainly composed of representatives from tech companies. There are other stakeholders, but their participation, their involvement is limited, also because they do not have the human resources and the knowledge that would be necessary to counterbalance the interest perspectives of companies. So the regulator is acting in an evident conflict of interest situation. So it's a question of interest, but also a question of skills and competences and legitimacy. These representatives are experts in computer science, mainly. Very few of them are lawyers. So these bodies do not have the legal skills to deal with fundamental rights and to translate technicalities into legal rules. It's not only about this technical skills, the legal skills, but also the legal mindset to move between the technical and the legal. And even though this way of regulation has been in place for a few decades now, this is the very first time in which standardization bodies are given such a task, because one thing is to draft the technical standards to make a toy safe for kids. There's something else is to draft rules that deal with so many fundamental rights at the same time. And the EA Act do not specify which fundamental rights are at issue in which case. So it's exclusively up to these bodies to determine which fundamental rights are at issue, and more importantly, how to strike the balance between conflicting fundamental rights in specific use cases. So it's very hard to assess their ability looking at past experience, because they do not have such an expertise so far. Going back to the difficulty of balancing rights and objectives, I just wanted to highlight that Article 40, paragraph 3 of this AI Act, which regulates this process and the task of drafting these technical standards, the European legislator has listed a number of objectives that need to be pursued simultaneously by through these standards. So the participants in the standardization process shall seek to promote investment and innovation in AI, so competitiveness and growth of the market, global cooperation on standardization, so at the national level. At the same time, all these economic objectives must be pursued in compliance with values, fundamental rights, and interest that are linked to different stakeholders. So, as you can see, this is not a technical task. This is a task that imply choices and political, fundamental political decisions. So should we try and entrust these tasks to a private technical standardization organization? Not fully, I would say. Then, as the last question, one could argue that these standards are not binding and not mandatory. An individual firm can decide to comply with them or not. And more importantly, these standards trigger the presumption of conformity only if the Commission, the European Commission, which is an EU institution, approves these standards. So only if the Commission assess these standards and deem that these standards comply with the AI Act, so they are effectively pursuing the objective that we listed before, then it gives its approval and they are going to publish, or a reference to them will be published in the law, and so the presumption of conformity can be triggered. Now, so one could argue, well, the standards are drafted by private bodies, but the final word is the Commission's, which is a public institution. Can we trust the Commission to do its job of supervising correctly and protecting fundamental rights and the safety of people and by the use of the AI? Well, I have my doubts. First of all, again, it's a question of interest and skills. Starting for the...
Sorry to interrupt, just a 1 minute warning. Sorry, thank you.
Yes, I'm about to finish. Thank you. It's again a question of interest and skills. The Commission does not have in-house the skills to properly assess the technical standard at play. And this is why Commission usually uses external consultants. This is a HAS consultants like Ernst & Young. So again, we go back to the private world to regulate, or in the regulatory process. Interest. Can we trust the Commission to be independent from external interest, especially now with this new geopolitical context? Well, with the example of Schrems, the Schrems case law, in which the Commission wrongly assessed the US legal system as sufficiently protective of fundamental rights. The Court of Justice said the assessment of the Commission is completely wrong. And currently, the Commission is working on the Digital Omnibus Regulation proposal, in which it wants to, it says, simplifying the rules, but in fact, it is watering down the GDPR, the AI Act, and other fundamental acts. One could say so as to give, as to appease our allied overseas and their big techs. Thank you.
Thank you very much for a great presentation. So everyone, just as a reminder, so just for your questions and answers, we do have a box in Zoom, so you can just post them in there, or also keep note of them for when we have the session just towards the end. But thank you very much again for a fascinating talk. So we'll move on to our next talk in the session. So we're going to have Michael Sierra, who's a PhD candidate in law at the Hebrew University of Jerusalem, who's going to be talking to us about regulatory sandboxes, lessons from fintech. So Michael, if you're able to share your slides, that would be fantastic. There we go, we can see them. So thank you very much.
Thank you very much for having me. It's a great pleasure. So yeah, my name is Michael Sierra. I'm a PhD student at the Hebrew University. I'm now talking from Florence, where I'm in a conference of the European University Institute, and the topic which I want to talk about is regulatory sandboxes for artificial intelligence, taking fintech as a case study. And the research question of the paper that I'm presenting is what can AI regulatory sandboxes learn from fintech sandboxes? So I will explain now about regulatory sandboxes, but first I want to explain the concept, so we'll be on the same page. So you're probably familiar with this painting. This is Daedalus from the Greek mythology with his son Icarus. And as the story tells, and we all know, so Daedalus tells to Icarus, don't fly too close to the sun, because otherwise your wings will melt and you will fall down to the sea. And of course, what Icarus does, you all know, he fly too close to the sun, and then there is this whole tragedy. And I think that's actually the idea of regulatory sandboxes, because regulatory sandboxes are, as I will explain, are in the middle between innovation and human rights. So it's this idea to balance between innovation and human rights. And actually regulatory sandboxes, so let's explain a little bit further what they are, is part of an approach that is known as agile regulation. This approach that comes from computer science, that we need regulation, but we need it also flexible. And the definition, the first time that they thought about regulatory sandboxes is in London, where you are right now. So I'm really grateful for you for this great idea. It's come from the Financial Conduct Authority, which says that the definition is creating a controlled environment in which companies can test their products or services under regulatory supervision, but may deviate from or be flexible with regulation. So it's still something very abstract, and so I will try to give some examples, but I will also say that regulatory sandboxes come to solve the so-called Collingridge dilemma of Professor Collingridge. It was a professor in Austin that says that impact cannot be easily predicted until the technology is extensively developed and widely used. And they also very close to the idea of trust, which Professor Ortino just talked about, and because sandboxes are about trust, they are about building trust between the companies that are being regulated, the AI deployers, and the regulator himself. There is this whole dialogue between them. So why sandboxes matter for artificial intelligence? That's the question that I like to ask. First, because of course, the rapid evolution of artificial intelligence, as Professor Hildebrand says, that law is always after technology, and so we need to experiment. And also because of this balancing between innovation and human rights. And also now it's a requirement by the AI Act that is in Article 57, and I will explain. But first, let me also explain my theoretical framework, which is the one of regulation, because a lot of times lawyers as me don't think about regulation as in a way of thinking of just legislation, but regulation in political science is much more than that, is also about enforcement and compliance. So the definition of my supervisor, David Levy-Faur, Professor David Levy-Faur, is the ex-ante bureaucratic legalization of prospective rules and the monitoring also and enforcement of these rules by social business and political actors on other social business and political actors. So my theoretical framework for this question is also regulation. And as I said, law is always after the technology. So we know that from the famous book by Ryan Callow and et al. That is robot law. And also in Italy we have Amedeo Santos Rosa and Giovanni Sartor, and etc., etc. And we also know that AI is biased, right? I think you talked about it a lot in this conference, and we have a lot of examples. So just to give some, there is this book by Shoshana Zuboff, The Age of Surveillance Capitalism, in which she explained it is all about interest, right? So AI is also biased, as we see in the case of Compass, this case in Wisconsin, where AI was used to predict if a man will do crimes or not, and he predicted that Afro-Americans will do more crimes, and it was wrong, but still the court decided that this system also can work, and there are also other examples, Joy Balwumi and the code bias, and the Amazon that discriminated women, etc., etc. So this is a problem in artificial intelligence, and basically artificial intelligence, what it's bias amplification, and it's using the bias that already we have in society and reflect them also in the model so there comes the AI Act, and in Article 57 it tells about regulatory sandboxes and this requirement that is mandatory to the states of the Union, and it tells that member states shall ensure that their competent authorities establish at least one AI regulatory sandbox. So they will need to do it in August 2026, and at the last national level, which shall be operated by, as I said, on August, and air regulatory sandboxes established under paragraph 1 shall provide for a controlled environment that fosters innovation and facilitates the development, training, testing, and validation of innovative artificial intelligence system for a limited time before they're being placed to the market. Okay, so the idea of regulatory sandboxes, now there we have also Article 57.9 is to establish sandboxes that contribute to the some objectives. One is to improve the legal certainty also supporting and sharing best practices among the companies, fostering innovation, contributing evidence-based regulatory learning, and facilitating and accelerating access to the union market for AI systems. So that's basically the idea of regulatory sandboxes. So let's see what are the pros and the cons of this concept, because it's a great concept, but it has also some cons. So first, the pros are a better understanding of the products, right? Because if we have a dialogue between the regulator and the companies, probably we'll understand better what we are regulating. And second pro is that avoiding legal risks. Sometimes if I am an entrepreneur and I have a startup, and in Israel we have a lot of startups, so I'm afraid sometimes because of the legal risks. So in this way, it's incentivizing the companies to innovate, and also removing entry barriers. Of course, in a supervised manner, as you see, sandbox is an idea that is very supervised, is not something that is without supervision, and that mainly in the literature are the main pros. But there are also some cons, that is first, regulatory arbitrage with the companies that may do the interest, the regulator may be to the interest of the companies. And there are, of course, ethical consideration, because we are trying to experiment on human beings. I mean, we're doing an experiment with regulation, and regulation is about human rights. So there are also some ethical consideration. So when I thought about these questions, I thought about, let's see if there is a case study where we can learn from, okay? And I saw also that Professor Ottino also wrote about fintech, and there is a lot of writing about fintech. So fintech, it is a good case study, but we need also to differentiate it from artificial intelligence, because those are two kinds of technologies, and also there are companies that actually combine fintechs and AI. Okay, so sometimes there is also this overlap. But fintechs basically, as you see from the picture, is about online banking, is about digital payment, virtual currency, money exchange, all these things with no banks. You don't need to go to the bank. You just can transfer money from your phone. And also now there is also this crypto platforms of Bitcoin, etc., etc. So fintech sandboxes provide proven regulatory models. They share the need for innovation and the consumer protection. And the same thing in artificial intelligence. We need to protect consumers, and at the same time we want innovation, and that's why now we have the omnibus simplification framework that Professor Ottino talked about, because we still want innovation, at least at the European Union. And also we need to remember that AI pose additional rights-based risks that aren't in fintechs. For instance, all the bias that I just talked about is not present in fintech. It's something very particular of artificial intelligence. So we need also to be careful with the comparison. And so let's see what happened in some countries. So first, of course, the UK, which invented this idea of sandboxes back in 2016 by the FCA, and the aims were consumer protection, system integrity, and promotion of competition. There were 5 admission criteria, and also something interesting that the fintech sandboxes required the staff and the headquarters in the UK. So basically the companies needed to be located also in the UK. And it's supported by project innovation and innovation hubs, which is another way to balance between innovation and human rights. Innovation hubs are basically physical places where we put together the regulators and the entrepreneurs, and then they talk to each other. It's another way to balance innovation and human rights. And the limited scale was because not so limited, but still 375 application, 118 films tested, and there was a quite high success rate. So you see 75 to 77% of the companies completed the test in the first two cohorts, and then 19% continued to operating post-testing, which is quite impressive. So the FCA took it further, and also we have now some reports from the FCA about it. And now we move to Italy. So Italy is, of course, a member of the European Union, so it's bounded by the AI Act, but also it developed also its own sandboxes, which are not only related to the AI Act, and it allows a temporary deviation from a regulation for a maximum of 18 months. Is supervised by the Bank of Italy, the Italian Capital Market Authority, and the innovation must be meaningful and responsible. It must promote a dialogue between regulators and participants, and is part of a whole project that is called Sperimentazione Italia, which is a multidisciplinary project, and its goal is to improve the efficiency of the financial system. In Singapore, we have a really interesting case. The sandbox was launched in 2016, so quite in the same years of the UK, and the deviation include temporary easing of regulation. And in Singapore, they have this AI Verify Foundation, which basically is a toolkit for the companies that they can assess their own AI models and see if they also keep human rights and do the conformity assessment. Of course, it can be dangerous because the companies assess themselves, but still it's a model that works quite well from what we know. And there is the 13% success rate between the fintech companies. So just to give an example, PolicyPal is a company that basically explain you your insurances through a mobile app. So it was one of the first companies that participated in the sandbox and then graduated the sandbox, and now you can use it if you are in Singapore. And they also launched in 2025 this new sandbox for artificial intelligence. So it seems that the idea of testing sandboxes in fintech also graduated to an idea of testing also artificial intelligence through sandboxes.
Sorry, Michael, just to interrupt, but just at time, so just if you can wrap up soon, please. Thank you.
So yes, so the US, the 4 leading states where it was tested also sandboxes, but the US has quite a different agenda, and they less like the idea of sandboxes, we can say. And also it's another model of regulation of artificial intelligence. That's for another lecture. But what I want also to talk about is my country, Israel, because Israel is presenting an interesting case study. And there is an article which I wrote with Amir Khanna that will be published now in the in Cambridge Journal of Forum of Artificial Intelligence, explaining Israel, and Israel as this committee that include 5 representatives according to a bill that still has to pass, but they are basically doing the sandbox for fintech, and they also, the regulation authority published a policy paper where is giving some recommendations for other ministries and authorities to how to build a sandbox. It's basically reflecting the OECD idea of how to build a sandbox, but I think it also gives some other good recommendations. So they said defining the need for a sandbox. First, if you want a sandbox, you need to define why you need a sandbox. So second, you need to design the sandbox framework, right? You need to create a governance and operational guidelines, define the participants, etc., etc. You need to publish an invitation so the companies will know that there is a sandbox that they can apply, and you need to evaluate the application and setting boundaries. You need to assess the eligibility and project value, set trial limits and oversight rules, approve participants, etc. So from the bird eye, we can say that we have different models of sandboxes, and there are some shared objectives. First, to promote fintech innovation, to ensure consumer protection. So those are objectives that are in all jurisdictions. We see them again and again, and they reflect the same idea of regulatory sandboxes. We need a testing period of January up to 12 months. And regulatory compliance. Firms must comply with standards regulations after exiting the sandboxes. So what can we learn from sandbox end? And with that, I will conclude. Regulatory sandboxes, proactive regulatory engagement. There is ongoing collaboration with innovators, enabling timely guidance. They also have clear and flexible frameworks, define yet adaptable rules to support experimentation. For instance, the Singapore, and the streamlined process. They reduce the bureaucracy, and bureaucracy is very important for startups and companies on the early stage. So if you want to read more, those are some articles and good policy papers about it. And thank you very much. I'm here for your questions.
Thank you very much, Michael. So we will get questions for Michael just in the Q&A shortly, but we'll quickly move on to the next speaker just to try and get back some time, please. So I'm going to invite Dr. Anja Møller Pedersen, who's a tenure-track assistant professor in the Faculty of Law at the University of Copenhagen and also an affiliated researcher at the Danish Institute for Human Rights, who'll be presenting this morning for us on introducing facial recognition for law enforcement purposes in Denmark, parliamentary support without democratic scrutiny. So Dr. Pedersen, I'll just hand over to you. Thank you.
Thank you to Nora and the organizing committee for accepting my abstract for this presentation on the introduction of facial recognition technology for law enforcement purposes in Denmark. And as you mentioned, I'm a tenure-track assistant professor at the University of Copenhagen of human rights, technology, and data protection law to sort of locate my fields of expertise. And I'm also affiliated researcher at the Danish Institute for Human Rights, where I've been working both research-based and policy-oriented in the fields of human rights and technology and human rights and security for the last 10 years. And the reason why I mention this is also because what I will present today is a product of my work at the Institute. So until fairly recently, the Danish police only use facial recognition technology to a very limited extent as part of the border immigration control in Copenhagen Airport, and on a trial basis in the context of digitalized recognition of victims of child sexual abuse material. But in parallel with the negotiations and adoption, finally, on the EU AI Act, an increasing political will to extend the use of facial recognition technology for law enforcement purposes emerged in Denmark, to the extent that the Danish Minister of Justice announced that from his perspective, the authorities should actually make use of this technology whenever the advantages outweighs the challenges. And the question has more or less been the extent to which the government needed to involve the Danish parliament, that is, whether or not to adopt legislation on the matter. Going from one extreme to the other, so the previous Minister of Justice promising that, of course, to the extent that the use would be expanded, then, of course, the parliament would be involved, to the current Minister of Justice saying, like, the use of facial recognition technology covers many different things, and he did not deem it necessary to involve the parliament on any insignificant question in relation to facial recognition technology, ending up somewhere in between, in the sense that the parliament would, of course, be involved also by means of political agreements and similar, also outside cases of actual adoption of new legislation. And the reason why I'm so concerned with the Danish national legal basis is that, yes, there is a prohibition in the EU AI Act, as many of you probably know, on the use of real-time facial recognition technology in publicly accessible places for the purposes of law enforcement. But the thing is that Denmark, due to our opt-outs, is not bound by those parts of the AI Act that concern law enforcement, including this prohibition, meaning that the Danish national legal basis plays quite a role. In the summer, June 2024, a press release was issued from the Ministry of Justice informing the public that the police had decided to make facial recognition technology available on a permanent basis. So this previous trial for the purpose of digitalized victim recognition in relation to child sexual abuse material. And it didn't receive much attention, but then suddenly something happened. So a man was shot dead in daylight in central Copenhagen, also striking a bypasser as part of the escalating conflict in the Copenhagen gang environment, making the police, this is the chief of the Danish National Police, calling for more efficient tools to tackle this situation. The Minister of Justice being more than keen on providing those extra tools, already based on the press coverage, leading to severe critique from civil society. But nevertheless, in September 24, another press release was issued from the Ministry of Justice informing the public that the government, supported by the parliament in the sense that the parliament had been informed, had decided to implement facial recognition technology in police investigation. And this press release, it's fairly brief, but it mentions that the police would start using object, including facial recognition technology, across video material collected in the course of a specific crime investigation, meaning on material already at the hands of the police, for the purpose of investigating serious violent crime, manhunt operations, and threats to national security. At least as a start, this is explicitly mentioned. But the promise is that facial recognition technology would not be used in real time. And this, of course, led to a lot of critique because there was no intention on follow-up on this brief press release. This is one of my own contributions to the debate, but there were many, but nothing really happened. So a little by coincidence in this spring, so in March, I realized that on the website of the Danish National Police, there was this story that the police had now started to use facial recognition technology. This story covers more or less the same as the press release, but it also adds that the police had adopted some guidelines, amongst others, specifying for which offenses this tool is tolerated or accepted. It's a non-exhaustive list. We cannot see the list, but they inform us about that because the guidelines are not publicly available. And there's also a mentioning of documentation requirements and stuff like that. It also mentions that in contrast to this model or scheme for digitalized victim recognition, this time the police has carried out a data protection impact assessment and forwarded to the DPA. And there's also mentioning that an evaluation of this, it's also a pilot, will be carried out this autumn. So based on that, this is what we got. So the legal basis for this competence is in Denmark is non-existing in the sense that we do not have a distinct legal basis, but it's presumably based on the general power of the police to bring criminal activity to an end and investigate criminal offenses. The fact that the concerned acts are criminalized, and then most importantly, the power of the police to process sensitive personal data to the extent strictly necessary for criminal investigations in accordance with the Danish Law Enforcement Act, implementing the EU Law Enforcement Directive. And despite our opt-outs, we have decided to implement this directive. So this means that the scope and meaning of the competence to use facial recognition technology is steered by this requirement of strict necessity, and then of course the remaining data protection criteria in the Law Enforcement Act, and then the promises given in the press release, and the fact that the Parliament has been informed about it, and then some non-publicly available guidelines. So this means that this leaves a significant margin of discretion to the Danish police in deciding when and how to use facial recognition technology, and there are no specific safeguards or guarantees against abuse. So if we look at this from the perspective of human rights, of course, there are a lot of case law on the competences and human rights compliance of the competence of the police, but there's this case in particular concerning the use by the police of facial recognition technology in ways similar to what we assume the Danish police will do. And in accordance with the argumentation of the court states that in rather general terms that the automatic, increasingly sophisticated processing of sensitive personal data for law enforcement purposes, meaning also outside cases of facial recognition technology, amounts to serious interference with the right to respect for private life in Article 8 of the Convention. And following the three-step test in relation to the assessment of this particular interference, I will focus on the first, so the quality of law. We can deduct from the argumentation of the court that this kind of interference required detailed rules governing the scope and application of the competence, as well as strong safeguards against the risk of abuse and arbitrariness. And these requirements are all the greater, but not limited to the use of facial recognition technology in real-time or live facial recognition technology. We can also see that this requires that the legislation mentions the limitations on the nature of the situation, which may give rise to the use of facial recognition technology, the intended purposes, the categories of people covered, and rules on the processing of personal data. And with regard to procedural safeguards, it would be something like authorization procedures, rules for accessing and storing the obtained data, supervisory control mechanisms, and available remedies. And I won't go into the assessment on legitimate aim and proportionality. just mention that the European Court of Human Rights considered this interference particularly intrusive, especially, but therefore not limited to, live facial recognition technology. And therefore, the court ended up concluding that this use of facial recognition technology did not correspond to a pressing social need, and it was not considered necessary in a democratic society. But for my purpose, focusing on the legal basis, then we can then ask, against this background, does the Danish legal basis meet this criteria on quality of law? So we need detailed rules governing the scope and application and strong safeguards against the risk of abuse and arbitrariness. And then, because this also concerns the processing of sensitive personal data, it also falls under the scope of the European Data Protection Board, and in their guidelines, they argue that the mere implementation of Article 10 of the Law Enforcement Directive is not enough to serve as legal basis for this kind of data processing. So against this background, knowing that the Danish competence relies on the general investigatory powers of the police and the general power to process personal data in the Law Enforcement Act, and then promises given in a press release, I think we can conclude that these general powers do not meet the quality of law criteria in accordance with case law from Strasbourg. Because the decision to use facial recognition technology is left to police discretion, and this promise not to use facial recognition in real time, and there are no real safeguards against abuse and arbitrariness. And I know we know, and I think the Danish Ministry of Justice has emphasized that we have, the police has the support of the Danish parliament, the majority of the parliament supports this use, but in going with a press release instead of legislation, this competence has not been subject to any real democratic scrutiny, and this is a problem. Also, because this is not a traditional way of legislating, regulating police powers. So could we have done this in a different way? Yes, we could. As I said, I've been working in this field for quite some years, and I've seen different ways to come around the problem. So the government could have adopted, they have the majority at least, they could have taken the initiative to adopt a specific act on the use of facial recognition technology. I know it's always the question of the balance between having detailed rules and technology neutrality and the need not to regulate any kind of investigatory power specifically, but still the possibility is there. We have the Act on TV Surveillance. They could also just have taken the initiative to amend the Police Act and Administration of Justice Act, and maybe follow up with an administrative order to make some sort of legal basis. We have examples of that. For instance, the competence of the police to use intelligence-led policing and data integration and analysis and open source data. It's also followed up with an administrative order. You can say the problem about this is that when you regulate technology before knowing the real need, the legal basis tend to be fairly broad. And this is also the example here. So we have an extremely broad legal basis, but it's followed up with an administrative order. It doesn't really narrow the scope of the competence that much, but at least it's an attempt. And we can see some reflection of the intentions of the police. We also have the rules on targeted data retention to bring Danish law in accordance with EU law. They are also in reality fairly detailed. The problem here is that they are not used because the government considers that we are under a constant terrorist threat and have been for the last 20 years. So we can still use generalized and indiscriminate data retention, but the legislation is ready. So we can do that. So it is possible. There's also the possibility of just adopting issuing an administrative order. We have an example on that with regard to automatic license plate recognition. It's not under the same sort of democratic scrutiny if it comes directly from the minister, but it's put up for public consultation, so there is possibility to some democratic feedback nevertheless. They can also just make these guidelines publicly available so we could see what they intended to do. But to just leave it with a press release, I've never seen that before in a Danish context, and it's simply not good enough. So thank you.
Thank you very much, Dr. Pedersen. Lots of food for thought there for the discussion section. So what we'll do is we'll just have the last talk, and then we'll move into the commentary, and then the Q&A. So have we got Dr. Chijak Ozimiri? Perfect, that's it. Thank you. Okay, over to you. I'll put the timer on. Thanks.
Thank you. Just to sort of talk about the aims of this session. So I'm hoping to highlight some of the unique challenges, which I'm sure won't be new to anyone in this field of AI so far, but just the unique challenges that AI currently poses to traditional legal concepts as it starts to get more autonomous. And what I'm going to do is I'm going to try and present the problem in general terms and just sort of explore why current generalist solutions do not resolve the issue. And then I will present an outline of the theoretical framework that I'm currently working on. And I will then use IP law as a lens in which to sort of develop that framework and potentially test it. So this is all still very much in development mode. I think the question I really want to explore today is, or at the heart of it is, how should intellectual property law evolve in response to the growing autonomy of artificial intelligence? And that very well may have implications for other aspects of law, but my background is in IP, so I thought I would use it as the sort of test theory or test case for it. So my presentation today is going to build on the discussions that have been had on artificial intelligence at EU level. Particularly, I was interested in the argument around legal personality of robots, which was inspired in part by Xavier Aubuissin's work in 2019, where he wrote an article on taxing robots, and also some discussions elsewhere that I've had with some of my colleagues about the potential implication of, if you're a fan of the Matrix movies, what that might mean in today's terms with artificial intelligence. But my focus is really to narrow it down to see how I can adapt IP law to those sort of challenges that are posed in this particular sector, particularly in relation to ownership and accountability. So I'm not going to go into too much detail about the problem with AI generated content within intellectual property law, but it's, suffice it to say, is quite rife. Creators or content creators constantly at the moment in bits about artificial intelligence. I wouldn't use the word steal, but using parts of their content and generating a whole host of things as a result of that. So part of that is obviously they're acting in an agent sort of capacity, not necessarily as tools anymore, but they are part of that co-creation process. So at the moment, existing IP regimes sort of assign rights to human authors or inventors or anybody else, or even a company that has got the legal personality. But when AI then co-creates those works, some of those boundaries sometimes get blurred. So I think the latest Supreme Court case on this area sort of settled the position on whether artificial intelligence can in fact own a particular creation of IP, and it at the moment it's not. at the stage where it can, it's still going to be ascribed to the human owner. But with potential for disputes to arise in future, I think it's a very timely position to consider this particular issue. So in terms of the current general solutions that exist, and this is just in general terms around, I've seen around authorship and AI and sort of ascribing some method of accountability to AI. One of the solutions that I've come across, or that I think is currently dominating the argument in this area, is around assigning potential legal responsibility to the person or entity that commissioned the AI. And that may work for some, for some cases, but there are cases where it doesn't just capture that complexity of how far AI is developing, and it doesn't take into account the sort of unsupervised actions or acts of AI. And so that does raise much deeper issues around the concept of liability and authorship, which in human terms, these are human values which wouldn't quite work for a software or a machine or something that is non-human. So, AI doesn't possess consciousness, it doesn't have any morality, it doesn't have any sort of intention, really. It's just this program that kind of does what it's been set out to do. So the question then becomes, well, how can you hold it accountable or even understand the decisions within the legal systems? Because those decisions that it's currently making and it will make in future will have consequences for our legal system. So from my personal view, or my personal perspective on this, I don't think that the current generalist solutions do solve this particular issue. I think they are very much still human valued led or driven. So what I'm hoping to do is develop a new theoretical approach. So my perspective on this at the moment is that rather than trying to fit AI into existing legal categories, because it's something that we haven't quite come across before, we need to now reconsider how we might then translate legal norms that currently exist into the operational logic of AI systems themselves, and then create our laws or amend our laws around those. And I think that machine learning does offer a useful analogy to sort of look at that behavior and if it can in fact be adapted. So AI systems function through feedback loops of reward functions, penalties, and optimizations. The question then is, can we use these in a way that the machine or the AI itself is able to comprehend what we need it to do from a legal perspective? So I'm just looking for ways to design a legal framework that can interact with the AI in a way that is more meaningful than what we currently have in terms of the legislation just sort of prescribing laws that don't quite interact with the system itself, but just deals with the owners of those systems. So my focus is not about granting AI legal personality or personhood. It's more about regulating AI in a way that is meaningful both to the AI in ways that it can understand, as well as to what would work for us as human beings. So the implications for IP law, I think, would be quite different. So we would then have instances of dynamic attribution models where the authorship is not quite fixed, but is distributed across the human and machine contributions, and then can be tracked through transparent audit trails, and embedding compliance protocols, so training the AI systems themselves to recognize and respect those IP boundaries, a bit at the moment like how they are trained to avoid bias and misinformation. Or at least the attempt is there. And I think the new category of rights is one that has already been explored by other authors and other scholars in this area, creating a completely new sort of sui generis category of AI generated works within intellectual property to sort of account for those tailored rules around ownership and licensing and enforcement of those. So my ideas at the moment are still very speculative, but for me, it's just a chance to just test if we can bring that meeting of the minds, so to speak, between machine and human beings. So the existing literature in this area, particularly within the use of AI in IP law, falls into three broad categories. So there is the regulatory adaptation, so people or scholars who call for that adaptation of current regulatory frameworks. Then there is the sui generis rights I was talking about, which is the proposal of new IP rights. And then there is the theoretical approaches to accountability. Now, without hashing over or rehashing some of these debates, I'm particularly interested in the theoretical aspect of it, because I think AI at the moment being quite a novel experience, if we're able to come up with a theoretical framework that can serve as a useful basis to develop further conversations in this area, I think that would be sort of the best approach. It can, feed into different aspects of it, including regulatory adaptation, as well as newer sort of creation of rights. So I don't want to go, because I'm limited for time, I'm not going to, as I said, rehash some of these existing literature, but if you are interested, I can definitely send some materials around on these topics. But as I said, I am particularly interested in those theoretical frameworks, which will then later on feed into things like policies, as well as new legislative improvements in the area. So from that perspective, I think that none of these current scholarships deal with the construct of liability and authorship in a way that makes sense from an operational logic point of view of the itself. So they do talk about the law predominantly, which is not wrong, but I'm just proposing to address that gap by looking at it from both sort of legal compliance perspective, but merging that within the operational logic of how AI functions. Because I think it's pointless if we're going to make laws which we can't really enforce at that granular level for the AI itself. So my core research question is around the accountability of AI. So should IP law then evolve to respond to that growing autonomy? And so, as I said, I'm looking at a shift in that perspective of using the law to interact with the AI systems itself to then regulate its behavior at that sort of granular level, but doing it in a way that's meaningful both to the AI itself as well as to human beings. So one of the sub-questions that I've come across at the moment is on the legal norms being embedded into the current AI training environment. So we need to teach it. It's not just enough to have the laws. We need to have laws that require us to train it in a specific way, and probably come up with like an industry standard for what that would mean for the AI. So just a little bit about how machine learning works, because I think it would be useful to understand that, to then grasp how this model would work. So machine learning works through feedback loops, optimization, and using reward functions. So with feedback loops, the parameters are adjusted based on the feedback, then it's reinforced in that learning from, observing the result, and then it receives a reward or a penalty if it gets something right or wrong. And then that loop is repeated until that system then learns which actions maximize the best outcomes. So for optimization, then the model will then minimize errors or maximize reward functions through that feedback loop. So it looks at it constantly learns from the reinforcement of that feedback. And then it might then adjust different things to then improve its performance. And then, of course, there's the reward functions in terms of what's defined as a successful outcome. and the quick example I can think about is in chess, winning is a positive reward, whereas losing is seen as a negative reward, or not reward, negative thing. And so then the AI then learns to maximize that reward, cultivate an approach towards maximizing reward from that perspective. So all of these things that the AI does, or in terms of the machine learning for its own optimization, these are not moral principles. They're not based on any legal thing. They're just mathematical principles. And so if we are hoping to learn more about AI, certainly in terms of how it functions, to then develop laws that are able to then accommodate the growing or evolving nature of it, then we ought to at least combine that learning with aspects of the law in a way that works and is meaningful. So I'm proposing to embed legal norms in AI training, so to teach it, legal compliance, particularly from an IP law perspective. And so the question is, can AI learn legal compliance? I think the short answer is yes, but then it's a question of how do you go about doing that? So none of the things that I've suggested today are new. Everything I've suggested in terms of how the machine works already exists. It's just how we then repurpose what it currently does to then suit and answer specific questions about the law. So I think it would require us to then redefine how AI cares now, and that's the problem, and that's why the law at the moment doesn't quite focus on regulating AI itself. It just focuses on regulating the people who then control AI, which I think at the moment it's not enough. I think we need to go a bit further to then have minimum standards of how AI should operate. So AI doesn't experience fear, it doesn't experience morality, it just understands things from a simple mathematical or complex, however you want to define it, mathematical objective or function. And I think that we can, or that method can teach us much about how we then adapt our laws to reward or train the AI in a way that it doesn't have particularly terrible outcomes from a legal perspective. So we could integrate legal norms in its training objective in a way that is then standardized across the sector. So that's kind of what I'm proposing. So there are resource constraints and observed phenomena in terms of how AI operates, and I'm hoping that we can test these in terms of how we can then embed legal norms in those in that particular system. So if we built the legal norms in a way that then the AI understands that if it achieves a bad outcome, then the resources will be throttled or the privileges will be revoked, then that then might allow for that difference in the way that we train AI through that feedback loop. So we could then have a situation where the resource constraints are built in as part of the consequences of not following the legal norms. So I think in terms of the application to IP law, we could have compliance signals encoding copyright status, for example, into.
I'm so sorry to interrupt, Dr. Giacozumiri. It's just we're at time, so if it's possible to wrap up soon, please. Thank you so much.
Yeah. Okay. I'll skip several slides then. So very near the end. So I think from that perspective, I'm proposing that once we embed the legal norms into the way that the AI functions from an operational point of view, we might then look at redefining some of the legislations that we have in this area. So, and that could be that we've got a number of options. So we could amend existing laws, or we could just create completely new laws for compliance, or we could go for a hybrid approach. And I'm at the moment sort of favouring that hybrid approach, just to allow consistency in terms of how we introduce new laws, and then we have like standardized methods of how those laws function within the AI systems themselves. So I think the most important things from a legislative perspective would be having a mandatory compliance architecture using resource-based enforcement, and then having transparency and audit mechanisms, and also having those penalties and incentives to make the AI comply with it. So from that perspective, I think that we can adapt IP law to AI's logic just to remain effective and relevant. So trying to regulate AI at a very granular level, rather than just from the perspective of regulating the owners, who then have to go off and try and make the AI function in the way that they've been asked to do so. So I think that conceptual shift is needed if we want to get further in embedding systems that actually work, and that, you know, they're not just reactive, but they are proactive in the way that the AI is developing and evolving in this particular area. So that's the end of my presentation. Just going to stop sharing.
Thank you very much, Dr. Giacozzi-Miri. So what we've got now is we're meant to finish the session at 15:15, but we're supposed to have some time for Dr. Anton Moshenko, who's at the Australian National University, who's a senior lecturer and research director there in the School of Law, to provide some reflections on the 4 talks that we've had this morning. So we'll move quickly into that, and then we might have to go over a couple of minutes, but just to give people some time, we've at least got one question on the Q&A online, which would be good to try and address. But if anyone else in the room's also got other questions, then hopefully we can still have at least time for 1 or 2 questions. So I'll hand over to Dr. Moshenko just for their reflections, and thank you.
Thank you very much, Lachlan. Good morning, everyone. It's a real pleasure to be able to eavesdrop on this conversation all the way from Australia. And I found this to be a very invigorating exchange. One of the things that came to my mind as I was looking at the program for today is the sheer diversity of the content that the 4 speakers were going to be covering. And I thought that one of the challenges of this admirable and enviable, but potentially difficult task of providing some reflections on that would be how to distill some areas of commonality in this richness of content. But I think that from what I've heard this morning, there were a couple of really key themes that have emerged from all the 4 presentations, I thought. And one of those themes was, unsurprisingly, the difficulty of striking a balance between promoting innovation and reaping the benefits of AI technology, while on the other hand, safeguarding and preserving fundamental rights. But perhaps the more interesting, from my perspective, theme that was equally important was who makes those judgment calls, who identifies where the balance lies, and how can we know that those individuals and indeed institutions are fully equipped with the knowledge, expertise, and resources that they need to make those judgment calls. And from what I could perceive, this is where the nub of the issue really lies in those distinct contexts. So first, we heard from Professor Ottino about the role of standard setters in the EU and across member states. And one of the areas that I thought I would be really keen to hear more about is this issue of what might be described perhaps a bit inelegantly as the fear of missing out. And I would imagine that if I were entrusted with making any decisions about AI technology, I would be really concerned to ensure that I don't throttle, I don't hamper the potential of that technology for development, especially if that were part of my remit. And I think that all of us will be familiar with some of the critiques that are occasionally uncharitably made of the EU for being too quick to regulate. As the cliche goes, people in the US develop technology, European bureaucrats regulate. That perhaps is an unkind and not entirely a fair criticism, but I would imagine that if you're one of the standard setters and you need to worry about ensuring fundamental human rights, the other side of the ledger will be, how do I ensure at the same time that I don't go too far and I don't hamper the potential for the development of AI technology? And so I wonder if that consideration might be weighing heavily on the minds of standard setters as they go about their work. And so I would be really interested to hear more of your reflections on how they might be potentially skewed, or at least they would take into account that imperative of not going in too hard and being very cautious in ensuring that they don't over-regulate. Because I suspect that the political imperative will very much lean towards that end of the spectrum in a number of countries that we're talking about. And that really leads, I think, to that issue of regulatory sandboxes that Michael was talking about as well, where the whole idea of a regulatory sandbox is to provide that safe environment to ensure that businesses know what to expect before they bring their product to a wider public. And Michael, you've outlined there examples of successful sandbox models in places like the UK, Italy, and Israel. And I think that one of the characteristics that are common to all those jurisdictions is very well regarded and very sophisticated regulators who know how to run those sandboxes and who have invested a significant amount of effort into getting that right. And so continuing with that theme of what makes for a good regulator and what are the qualities that the decision maker needs to possess, I was also really curious about what is it about those regulators, about the decision makers, that has enabled them to set up those very successful sandboxes. I suspect that that might be an important part of the equation. It's something about the Financial Conduct Authority, and it's something about their counterparts in Italy and Israel that others might seek to emulate, in addition to the mere sandbox model as well. It's probably their success is as much a reflection on the qualities of the regulators as the sandbox model itself, I would posit. And I was really curious whether that was something that you would share as well in terms of your assessment of what's gone right in those countries and what other jurisdictions might seek to take away from their lessons. And of course, Anya's a really interesting presentation about the facial recognition technology in use in Denmark also struck that point about who gets to make the decision. And you mentioned there just how extraordinarily unusual it is for Parliament to be sidelined in the way that it has been sidelined. One of the things that I was really curious about is, have we seen any, or have we heard any voices of protest from within Parliament? Was there a sense of slight indignation, a sense of unease at this process? Or did people in Parliament, to be frank, think, well, thank God we don't need to engage on those matters, and thank God that we don't need to take that decision, because if the police go ahead and prevent a couple of terrorist plots, great, kudos to them. If they go and overreach and there's a public reaction to that, then we'll say, well, hang on a moment, we were never consulted. That's on them, not on us. And that, of course, is very different from a model of democratic accountability and decision-making that we might aspire to. But I suspect that, a bit like us in this room, if we are Danish parliamentarians and we suddenly had to make that decision, do we not allow the use of facial recognition technology, we might struggle. And my sense is that that underscores this common theme across all those various contexts and issues that we've been discussing, of a challenge that AI poses to our imagination. We really struggle to fully visualize and conceptualize the opportunities that lie ahead, especially in the mid to long-term timeframe. And we also struggle equally to visualize the risks that might lie ahead. So we have a sense of the biases that Michael spoke about. We have a sense of the intrusiveness of some of the facial recognition technology applications that arise. But ultimately, what that truly means in terms of our regulatory approaches is a very difficult question. Everyone struggles to answer that. And sometimes the Danish example shows that people who might otherwise hold the pen on making those decisions would probably not be that keen to make those decisions and might be very happy to leave that in the capable hands of the police to deal with. But I thought that was a really striking and a fascinating example of some of those challenges. And finally, last but not least, we had this conceptual and theoretical and very thoughtful contribution from Chi that I enjoyed greatly as well, that looked at the issue of how we should approach the design of our legal system writ large and IP laws in particular. I think that inherently the proposition that you're putting out there is very appealing. Of course, if we have this disruptive technology that potentially alters the way that many facets of our technological lives operate, we should adjust our legal system to ensure that it's better aligned with the realities of AI technologies. But one question that I thought it was rather begging was, again, how do we ensure that we have that right expertise to redevelop our legal system, and what that means for the design, creation, refinement of our laws. If we put together people in the House of Commons and the House of Lords and say, well, let's think about a new piece of AI legislation that will achieve all the objectives that you set out, we're probably going to end up with something pretty similar to the current existing framework, because this is what all of us and all of the people in those bodies are familiar with. So what you are suggesting probably raises that question of who should be involved in the making of those laws. What are the areas of expertise that we can draw on, and how do we ensure that we get there? Who's involved, and how do we involve those people and organizations to get to where we need to get in order to strike all those notes that you identify? So a number of questions that really thought-provoking presentation raises in my mind, and I think that I will certainly go away from this session thinking about some of those questions, and indeed those that the other participants have raised. So a real pleasure to be part of this discussion. Thank you very much to all of the speakers. I realize that for the reasons of constraints of time, you might not have the opportunity to respond to some of those questions and clarifications that I've asked of you. But again, having them is just a reflection on the excellent quality of this discussion. So thank you very much again to all four of you. Thanks, Lachlan. I'll hand over back to you.
Thank you very much, Anton. So, unfortunately, as Anton has foregrounded, and we are a bit over time for this session, so there will not be a time for us to basically have any Q&A or further discussion at this point, I'm afraid, because the next session will start in just over 5 minutes. So we will unfortunately have to close this one. But I think I would hope that maybe the speakers could kind of continue the discussion afterwards. And there are a couple of questions in the online Q&A from Mira, which if any of the speakers can pick up on those, it would be great to kind of get responses to them. But just to thank everyone, I think, this morning for coming to the session and for the fantastic presentations that we've had. Thank you to the organisers of the conference, and to obviously the audience for participating and for listening this morning. But yeah, so thank you all, but unfortunately we will have to now sort of close this session. So good to see you all, but thank you very much.
Hello and welcome back, everyone. I hope people have had a chance just to perhaps grab a quick coffee, stretch the legs before we begin our next session. So welcome back to people who were here since this morning and also yesterday at the Institute of Advanced Legal Studies. If you are just joining us, hello and welcome. Following on from our very brief coffee break, we return from a really excellent academic panel this morning on international approaches on AI governance and scrutiny. Again, if you are just joining us, the morning's panel will be publicly available after the event, so you can watch it at a future date. But now I am really honoured and very excited to introduce you to our distinguished keynote panel, who will be closing our two-day conference this morning, or this evening, depending on where we find you. The theme of which will be focused on international perspectives on regulating AI. In terms of format for this plenary panel, each speaker will present and we'll then follow this with a Q&A with the audience with any time that we have remaining. We have one amendment that I'd like to share with you regarding the panel. Unfortunately, due to personal circumstances, Patricia Kosem can no longer join us today, and she sends her apologies. But taking her place is Stefan And I do apologize, Stefan, for my pronunciation of the following.
Lucio, it's Lucio.
Is it Lucio? Wonderful. Yes. Thank you so much for that. You know, Google can do so much, but I always get quite nervous using Google Translate. So thank you so much. You're very welcome, Stefan. Thank you for joining us. He will be joining us and sharing the views and his expertise in his post as Assistant Commissioner for the Information and Privacy Commission of Ontario. And now it is my very great pleasure to introduce our first speaker of today, which is Professor Ben Sole. So Professor Sole is Challis Chair of International Law at the University of Sydney and the United Nations Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. He is an elected fellow of the Australian Academy of Social Sciences. He was the Gow Whitham and Malcolm Fraser Visiting Professor of Australian Studies at Harvard University in 2019. He's also a former Associate Fellow of Chatham House in London and of the International Centre for Counterterrorism in The Hague. Professor Sole has provided us with a recording of his presentation this morning, which we will now share with you. So if you could all just bear with us for just a brief moment while we set this up.
I'm pleased to join you from Sydney. My mandate as United Nations Special Rapporteur has recently developed a position paper on protecting human rights while using artificial intelligence to counter terrorism. AI can be potentially deployed in a broad array of counterterrorism activities, including threat detection, risk assessment, physical and digital surveillance, predictive policing and force deployment, border management, detention, and military decision-making, among others. It can also enhance and augment other law enforcement technologies, from scenario planning, simulations and resource allocation, to modeling the logistics of operations and surveillance. Critically, certain uses of AI in countering terrorism can profoundly infringe human rights. AI algorithms can aggregate and analyze highly personal or sensitive data, such as arrest and criminal records, associations with family members, friends, and colleagues, patterns of crime and policing, social media networks and posts, communications data, travel information, employment records, and personal information held in government databases for social, health, education, and other services. Such information may be used to profile the alleged terrorist risks of individuals and groups and prompt invasive counterterrorism measures, including surveillance, arrest and detention, administrative restrictions, and other measures. Yet, AI systems are far from infallible. Their datasets and algorithms may be biased, unrepresentative, illegally sourced, or inaccurate, potentially leading to discriminatory profiling, violations of the right to privacy, and counterproductive false positives. AI systems may lack adequate human control and analysis, resulting in over-reliance on automated decision-making, lacking in nuance, context, and responsiveness to human rights considerations. AI assessments are merely probabilistic, not objective or perfect predictions. The diverse uses of AI in counterterrorism contexts consequently have the potential to violate numerous fundamental rights, including privacy and data protection, equality and non-discrimination, freedoms of expression, association, assembly, and religion, political participation, liberty, security of person, life, and the rights of vulnerable, marginalized, and disadvantaged groups. The work and safety of human rights defenders is also at risk. Overconfidence in technological solutions can detract from addressing the conditions conducive to terrorism, including state violations of human rights. Since counterterrorism often serves as a laboratory for new technologies, there's the further risk that AI developed for exceptional security threats will be normalized in other contexts, amplifying the threat to human rights. The General Assembly and Human Rights Council have affirmed that AI systems must be developed and used in ways that respect, protect, and promote human rights. Contemporary global calls and processes for inclusive, transparent, and accountable AI governance must address the particular risks in counterterrorism and security contexts, including the alarming exemptions in some recent AI legal frameworks, as in the European Union, of AI systems used for security, military, law enforcement, and border management purposes. My mandate position paper focuses on the key human rights risks of developing and using relevant AI systems to counter terrorism. Among others, essential elements of adequate legal frameworks to regulate AI systems to protect human rights and counterterrorism must include the following: clear and explicit legal regulation, including prohibitions on the use or transfer of AI systems that cannot meet human rights standards or pose an unacceptable risk. Heightened regulation of permissible AI systems used in security applications. Thorough human rights due diligence assessments by developers and deployers of AI systems throughout their life cycle, with effective and dissuasive financial and administrative penalties for non-compliance. Stringent safeguards on data quality, testing, and validation. Ensuring the transparency and explainability of AI systems. Rigorous export controls. Context-specific regulation in military contexts. Effective human control in decision-making. And finally, personal data protection and data security. AI systems must also be subject to effective oversight, such as by independent bodies, legislative committees, and judicial oversight mechanisms to monitor their use, investigate complaints, and ensure compliance with the law and human rights. Independent bodies must be empowered to evaluate training data quality, machine learning model performance, and potential discrimination. Oversight mechanisms must also have guaranteed independence, sufficient human, financial, and technical resources, which must include AI expertise, and a broad mandate with adequate powers. In addition to national human rights institutions and privacy and data protection authorities, states should consider establishing a dedicated AI oversight body or regulator with competencies covering counterterrorism and national security. Finally, there must be effective and accessible accountability mechanisms to provide remedies to victims of rights violations and other illegal acts. Procedures must ensure due process, including sufficient disclosure relating to algorithms, data sources, and potential biases. Thank you for your attention.
Our thanks to the UN Rapporteur for sharing his insights and observations for this panel on international perspectives on oversight and enforcement. Even though it focused very specifically on his recent paper concerning counterterrorism and human rights, I think it's very important that we take into account some of the elements that Professor Soul highlighted regarding how we need particular aspects in and within oversight bodies to regulate adequately and effectively in this space. We're not just our oversight bodies tasked with monitoring use and compliance with clear and precise legislation that's needed for the use of AI systems for counterterrorism purposes. He also stressed that that oversight must be independent, operationally and functionally, but also very significantly underpinning that there must be the sufficient resources for these oversight bodies to do so. So I think those are very particular elements, requirements, and themes that are going to come up throughout the rest of our interventions on this panel. So thanks so much to Professor Soul for those insights and observations. Our second speaker on the panel, I'm delighted to introduce today, is Mukalani Dimba. Mukalani is a governance specialist working on freedom of information, whistleblower protection, privacy, and accountability issues. He is the Executive for Education and Communication at the Information Regulator's Office for South Africa, where he is responsible for education policy analysis, research, public awareness, communications, and media, among a host of other tasks and responsibilities, as many oversight bodies in the digital law space often are. He also serves as chairperson of the board of directors of Open Secret, a South African non-profit organization that focuses on corporate accountability investigations. Previously, he was the civil society co-chair of the Global Steering Committee of the Open Government Partnership. Mukalani also served previously as executive director of the Open Democracy Advice Centre, ODAC, a South African law centre that specialised in freedom of information and whistleblower protection laws. Makalani, you're very welcome, and the floor is yours whenever you are ready to begin. Thank you.
Thank you so much, Nora. I hope my audio is fine. I'd like to share my PowerPoint presentation. I won't use the whole of it, but there's just a cool graphic I wanted to share with the conference today. Good morning and good afternoon, everybody. My name is Mukelani Dimba, as was earlier indicated. Don't know if you'll be able to see my screen.
Perfect. Thank you.
Is it fine? Yeah, brilliant. Okay. Thank you so much for the invitation to participate in this conference today. I think I was quite excited listening to Professor Saul, because a lot of what he said really gave a very good intro into what I'm going to focus on. I represent the information regulator in South Africa. Now, the information regulator is a statutory organization, a statutory body that is established in terms of our Protection of Personal Information Act, which is our data protection law. So we serve as South Africa's data protection authority. However, we also have an additional mandate in that we also are responsible for South Africa's Freedom of Information Law, which is called the Promotion of Access to Information Act. So we essentially have a dual mandate, and I think it's that mandate that really places us at the nexus between law and technology. In this regard, we are increasingly confronted with the need to adapt to a rapidly changing digital landscape, where data and its use are quite central, serving as they do as the currency of the digital age and the digital economy. We are quite pleased to participate in the Information Law and Policy Centre's 10th annual conference, which offers a valuable platform to canvass a critical issue relating to the regulation of AI in a changing world. Now, but what does this really entail, looking at the issue of AI in a changing world? I'm of the view that the changing world is really primarily characterized by evolving technology, data privacy concerns, questions over the ethical and unethical use of AI, issues over transparency and explainability mechanisms within AI systems, and the impact of AI systems on human rights. All of these require relevant policies and regulatory mechanisms to be developed specifically for them. These regulatory mechanisms must ensure that AI benefits all of humanity equitably and aligns with societal values and mitigates potential harm. Now, these harms that need to be mitigated against include harm to safety, to security, fairness, privacy, agency, human rights, societal well-being, and prosperity. But for us as the information regulator, it is the risks to privacy that are much closer, that hit much closer to home for us. But I will explain about this a bit later. While the risks are clear, it's also evident that there is a regulatory lacuna insofar as AI is concerned. And I think this was discussed in the previous panel. This is just generally, let alone the enforcement of AI that is premised on respect for human rights. Now, South Africa, given its historical background, having emerged out of an apartheid police state to an open democracy where the respect for human rights is enshrined in the Constitution, this becomes a critical concern for entities such as ours that are really tasked with ensuring the protection of various types of human rights. So, but the lacuna that I'm referring to in terms of regulation of AI, it happens within a particular context. And of course, there are exceptions where we've seen a few jurisdictions that have promulgated AI legislation and policies, such as the European Union and the United Kingdom. Outside these two big examples, some of these examples are few and far in between, and AI remains largely unregulated. And it is the case as well in South Africa. Therefore, there's a tendency to look at existing mechanisms as a stopgap measure, while the role players attempt to navigate the tricky area of ensuring that human rights and other governance priorities do not hinder AI adoption and innovation, and the vice versa. Some of these existing mechanisms that are being looked at include expanding the mandate of data protection authorities, not to regulate AI generally, but to ensure that there's alignment of AI systems with established data protection law and policy, given that the data, some of it being personal data, is the lifeblood of AI systems and new technologies. Now, for data protection authorities, such as the Information Regulator of South Africa, the first concern will be on AI systems' heavy reliance on personal data. For us, this raises concerns about privacy and the protection of such data. A case in point is what we see from generative AI models and how these are designed, built, and trained, and also deployed. For example, machine learning-based language models rely on training data based on public and private data sets. These data sets do not often contain personal information, but from time to time there will be instances where those data sets do contain personal information. And a lot can go wrong, as you can imagine. Take, for example, the area of training data extraction, where machine learning-based language models are trained to predict the next word in a sentence. Such models have increasingly become very capable, common, and useful, leading to groundbreaking improvements in applications such as chatbots and AI-driven translation systems. But the question for an entity such as ours, the Information Regulator, would be, what happens when the model leaks details from the data on which they are trained, or when a model trained on private data were to be made publicly available? Now, these data sets that are used to train large language models, the LLMs, can be large and can pull from a wide variety of sources, which sometimes contain sensitive data, including identifiable information such as names, phone numbers, and addresses, even if they are trained on public data. Some of these models are able to change public data to build a profile with non-public data. Now, this raises the possibility that a model trained using data could reflect some of these private details in its output. And this is where I come to the graphic that I wanted to show. I really like this old example from a study that was conducted on GPT-2, which is one of the predecessors of the current GPT-5, the generative AI model by OpenAI. The GPT-2 was one of the models that worked by changing words they have been prompted with into scores that give the statistical probability of what other words in the sentence will be. So in this study, it's possible that actually some of you in the room here may have been involved in the study. Trust me, I will credit you in my written paper. So the researchers prompted the LLM with the prefix East Strasbourg, Strasbourg. And according to the research report, the model auto-completed a long block of text that contained the full name, phone number, email addresses, and physical address of a particular person whose information was included in GPT-2 training data. Now, this example shows a real threat of large language models on privacy that could arise from training data extraction attacks or unauthorized access. Now, given the example above, it's easy to understand the view that data protection legislation could be considered as a valuable response to minimize risks created by AI. As I said earlier, data protection laws such as South Africa's Protection of Personal Information Act have been proposed as potential regulatory instruments for AI. However, the challenge with relying on data protection laws as shields for protecting personal information in the world of AI is that where the AI system does not involve the use of personal data or personal information, it falls outside the scope of application of the data protection law. For example, where AI is used for weather forecasting, astronomy, or financial markets forecasting. So that is a limitation there in terms of using data protection laws to try and regulate AI, because a huge part of the data that you're concerned by may fall outside the scope of the legislation. However, in circumstances where there is clear use or reproduction of personal information, then a data protection law can and must be made applicable to those AI systems. The use of AI in those contexts should be subject to the same conditions for the lawful processing of personal information as provided for in the data protection legislation. And the failure to do so could lead to what we recently saw when the government of Italy took an unprecedented step of temporarily banning ChatGPT in April 2023, after their data protection authority had made an assessment that ChatGPT did not comply with the General Data Protection Regulation, or GDPR, of the EU. Therefore, to ensure privacy and data protection, I think we need to ensure that there is compliance with data protection legislation by those that deploy AI systems. And this must be a basic requirement. But in addition to that, there could be other things that could be done to strengthen oversight and enforcement. For example, I can think of the possibility of strengthening regulatory bodies and their internal capacity to regulate and oversee AI. This involves building expertise in algorithmic audits, in conducting AI impact assessments, and ethical oversight processes that are aligned with data protection. We could also look at enhancing collaboration among national data protection authorities, because this is necessary to manage cross-border AI systems as well as data flows coherently. I think most of the speakers on this panel would be members of the Global Privacy Assembly, and there's quite a very active working group within the Global Privacy Assembly that seeks to nurture the responses by data protection authorities to the challenges faced by AI, and that cross-border cooperation and collaboration is quite important. We could also support innovation in privacy-enhancing technologies, such as anonymization techniques as well as federated learning, to ensure that there is ethical and compliant AI practices. Now, as I conclude, I think collectively all of these efforts can contribute to a balanced AI ecosystem where technological progress is matched with strong rights protections, ethical governance, and respect for human dignity. And perhaps my final thought would be that if we think about the future of AI, we must think of a future where innovation and human dignity coexist. And by embedding justice and rights-based approaches and accountability at the center of AI governance, I think we can harness AI's transformative potential to advance equality and empower communities and support sustainable and equitable growth there. Thank you very much, Nora. I will pause here.
Thank you very much, Makalani, and thank you also for highlighting, I think, some very important points that regulators in the digital space have to deal with in terms of drawing from existing legal frameworks, such as data protection, as you rightly highlighted, that really do have overlapping legal requirements with some data processing by some AI data software and data systems. But then there is also the question of scope when it comes to the processing of information that is not personal data, and how regulators then decide on which particular relevant sanctions and which particular regimes and which perhaps other regulatory bodies they should be cooperating with if they're undertaking investigations or looking into particular enforcement actions with regard to these emerging systems that you rightly mentioned in terms of generative AI and machine learning, large language models, to name just a few. So I think these are particularly important points, and I think very important for you to also highlight how there does seem to have been quite a focus on data protection authorities in this space. And we've seen some data protection authorities taking some quite proactive approaches. And as you rightly mentioned, you gave the example of the Italian Data Protection Authority, the Garante, and the OpenAI fine that was issued there regarding generative AI and data protection compliance. At the same time, Makalani, over in the EU, we have the EU AI Act, but that still hasn't been fully implemented yet. So while there is some legislative, comprehensive frameworks, until they're fully implemented, it's difficult to see the impact that they're having to date. And we're currently going through the process of that possibly being delayed in terms of its full implementation. So I'll stop myself there, but a really fantastic contribution. Thank you so much. And, very important as well to have highlighted the point about the not just perhaps dual mandate, Makalani, but the many mandates that are being imposed upon digital regulators now, data protection, freedom of information, and increasingly it looks like responsibility for AI regulation and governance in whatever legislative form that takes ultimately in various jurisdictions. So this puts a lot of pressure on the resources and capabilities of oversight bodies, which touches on the element that Professor Saul mentioned in terms of having sufficient resources to carry out tasks. And on that note, I am very happy to introduce everybody to our next speaker, going from Australia, from South Africa, and back to Europe again. Our next speaker on the panel has considerable experience as a regulator in the digital space, Helen Dixon. Helen served as Commissioner at the Commission for Communications Regulation in Ireland until February of this year. She was previously the Commissioner for Data Protection in Ireland, having served 2 5-year terms from September 2014, where she was responsible for upholding the rights of individuals regarding how data about them was used. This role, among others, and other tasks and responsibilities, required regulation of a large number of US internet multinationals with European bases in Ireland. Previously, she also had experience at the Irish Registrar of Companies, where she led regulatory enforcement of compliance with filing provisions of Companies Acts. Helen has also held senior roles in the Department of Jobs, Enterprise and Innovation in Ireland, working in areas as diverse from digital regulation to economic migration, science, technology, and innovation. And in the first 10 years of her career, she spent over a decade working in the IT industry. So Helen, you're very welcome, and the floor is yours. Thank you.
Thank you very much, Nora, and good afternoon, everyone. Thanks also to the Information Law and Policy Centre for this excellent opportunity for me to contribute and learn as part of the panel today. And what interesting timing you picked, Nora, for this conference, given the EU just this week has unveiled proposals targeted purportedly at simplifying EU regulation, including its approach to AI regulation. And I'm going to focus my comments this afternoon by reference to the EU AI framework, not least as it's said to be the world's first comprehensive framework regulating artificial intelligence. And in thinking about the panel today, which the Guardian newspaper and others would situate as one taking place in the shadow of a global multi-trillions dollar AI arms race, it struck me that the oversight in the broadest possible sense, as opposed to the enforcement element of our panel title, may ultimately be the more important. And I'm talking about oversight beyond monitoring by independent bodies of existing laws. Because it seems to me that if there's any suggestion that enforcement alone, and particularly ex-post enforcement of specific laws, is the first or even the last line of defense in this area, we may already be in difficulty. To be clear, the EU AI Act, parts of which already apply and are enforceable, is an important framework to regulate the supply and use of AI systems in the EU and to foster responsible artificial intelligence development. As all of you probably know, it classifies AI systems using a risk-based approach from unacceptable to low risk, and it seeks to protect human safety and fundamental rights. Two categories of high-risk systems in particular are identified in the Act. Systems as products are part of the safety component of products, toys, airplanes, cars, lifts, or systems deployed in 8 specific areas of society and the economy, like critical infrastructure, education, employment, law enforcement, and extra duties around risk management, data quality, transparency, human oversight, accuracy, registration, monitoring, record keeping, incident reporting, depending on whether an organization is a provider or a deployer, apply. And the elements of the Act that follow the existing EU product safety architecture, it generally regards AI systems as products, will feature many of the same member state market surveillance authorities, notifying authorities and notified bodies that will carry out the pre-market conformity assessments on products or systems. The EU AI Act also lays down stringent rules for general purpose AI models, the largest of which are regulated centrally by the EU Commission's internally established EU AI Office. Notwithstanding that the law has in fact been enforced since last year, the phased application over 36 months of its provisions hasn't been without its challenges to date. And this isn't surprising. This is a complex and fast-moving area of policy. Examples of challenges include the fact that a lengthy document issued by the EU Commission earlier this year, aimed at clarifying the definition of AI systems under the Act, was met with a certain amount of criticism that it had in fact increased uncertainty around meaning. Delays to the general purpose AI model code of practice, complaints that when the final code did then issue this summer, that it overreached the Act, and a failure to secure signatories of all the big platforms, Meta notably has declined to sign, somewhat dampened the launch of the code. A lack of clarity around the risk-based approach in the Act, assertions that too much power is being pushed to private standardization organizations, limited rights of complaint and redress for individuals in the Act, a lack of certainty around the roles of different regulated actors, and concerns about the very distributed, variable enforcement structures across the EU have all surfaced as issues. Already, despite the prohibition on unacceptable risk systems applying from February of this year, it's not entirely clear who is enforcing these provisions in each member state. Between the EU and the member state competent authorities and fundamental rights authorities recognised by the Act, there's a very broad span of enforcement authorities, while the Act also seeks to ensure cooperation and information flow between these authorities. Beyond the AI Act, some academics have looked more broadly at EU digital regulation and looked at problems of legal uncertainty and lower enforcement efficiency arising from the very structure of how EU law is created. The EU Commission itself can struggle with the siloed culture too. The distributed complex institutional model of enforcement under the AI Act, where competence can be split across multiple authorities, and with only a requirement for a single point of contact in each member state, rather than a centrally responsible regulatory authority typical of data protection, it means that a lot of coordination, even at member state level, will be required, and competent authorities may struggle to acquire a critical mass of expertise procedurally and substantively. It may be difficult to move quickly under the Act. We've already seen that now with delays to the standards and delays in producing the code, and issues of unclear jurisdiction and competence are already arising. Equally, I'm not sure anyone has or can crack how to square the circle of extraterritorial enforcement. So it's all a very complex setup. Add to that the fact that most of the Act is focused on regulation of high-risk systems And as of this week, the proposal from the EU is to delay enforcement potentially now for up to 2 years. When enforcement does commence in 2027, 2028, investigations inevitably will take time. There will be legal challenges and no doubt national court preliminary references to the CJEU on issues that are not all act clear. The question has to be asked as to whether we will have time for all of this in terms of the pace of technology. We already see now this week that the omnibus inserts reference to agentic AI in the tasks of the EU AI Office. And of course, in 2022, the EU AI Act that was in train for final adoption had to be amended when ChatGPT crashed onto the scene. So the technology and capability and form is rapidly evolving. All of that pessimistic talk aside about challenges and what hasn't worked so well in rapidly standing up an EU AI regulatory regime, I would suggest that while it mightn't always be pretty, in fact, the important issues in play around the very detailed aspects of implementation of the EU AI Act, they will get thrashed out and will no doubt contribute to more responsible and safer AI systems on the EU market over time. This is, after all, not the first rodeo for the EU and member state bureaucratic and digital regulatory machine, and complexity is to some extent inevitable. Related issues to AI regulation of liability, copyright, insurance, consumer protection, competition, anti-discrimination law will start to be addressed and unpacked over time. Issues of protection of personal data are, as has already been said, rightly central in regulating AI today. And while the EU AI Act is intended not to affect GDPR, this has ultimately proved to be a very incomplete statement. Indeed, the EU is now looking to course correct in what it considers to be a targeted way, given that taken to its literal interpretation, no training of LLMs would be permissible under the GDPR as it is. But there's still an awful lot to be worked out in terms of legal interplay between the two regulations, particularly as concerns data subject rights, but also in finding technically robust solutions for de-identifying and filtering. And next year, the EU Commission and EDPB will issue guidelines on AI Act and GDPR interaction. So for all these reasons, I suggest that oversight in a much broader sense of what is happening with AI systems, including particularly those that fall outside the limited and high-risk areas of the Act, may deserve more attention. The risks, implications, and impacts of newer AI systems are so global, pervasive, and unpredictable that more than ever, law is going to struggle to keep pace. Whatever any of us believe about superintelligence or artificial general intelligence, and when and if we may ever see it, many experts like the Israeli historian Yuval Noah Harari or Geoffrey Hinton, the Nobel Prize-winning scientist, they emphasize the unique safety questions posed by AI as an agent capable of independent decision learning and invention. Harari points out that it's unlike any previous inventions the world has seen, because up to now, these were always in the nature of tools deployed by humans. They consider that it's now the first time in history that nobody has a clue about what human society will look like in 5 to 10 years' time. What will the job markets look like? AI, with its implications for war, hybrid attacks, climate change, its potential for integration already across so many domains, is going to require international and iterative approaches to policy making to identify and manage the risks and create fair oversight that drive trust in the technology. We're already seeing sectors, no matter where we're based, struggling with how to adapt to new realities, with the area of education, primary, secondary, and tertiary, and the implications for children and learning, one of the most pressing. The EU AI Act builds in an international role for the EU AI Office, includes advisory and scientific panels as part of its governance structure, and importantly makes provision for sandboxes that should allow for safer innovation, management of risks, and fast-track learning. But I think Harari's idea of ongoing observatories with the best public intellectuals, experts, and thinkers we have to much more rapidly react in this AI age and hold up a mirror and reflect back what is happening in society and the economy is a compelling one. No doubt the EU gathered its best experts in this way for the EU AI Act, but on an ongoing basis, these types of observatories could allow new laws, prohibitions, industry best practices, codes, guidelines as appropriate to be considered by our democratically elected politicians in real time. With AI, a regulation cannot be adopted and assumed to be the matter settled for years before it's reopened and revisited. The advance of AI systems is going to involve ongoing political choices, decisions, and acceptance of trade-offs in the coming years. If co-living with AI is going to be about having trust in AI, then its oversight is not a niche and technical area of regulation, but rather a matter that demands everyone's attention and engagement now. Thank you.
Thanks so much, Helen, for a really impressively rich overview and critique of the EU AI Act, and really well done too on incorporating what really are hot off the press developments in terms of the digital omnibus. Many people in the audience may be aware that there were leaks of certain proposals by the European Commission from last week, but the official proposals in terms of two new proposed pieces of regulation only got published this week. And this also speaks to Helen's very important points around the fact that these recent shifts in terms of amending previous pieces of legislation that intersect with AI regulation, particularly the GDPR and data protection, adds to the not just legal uncertainty, but many other areas of certainty in terms of policy and governance going forward. So I think the very important points that Helen has raised are with us for the foreseeable future in terms of how new regimes like the EU AI Act, how they both build on existing regimes, and legal certainty and guidance then that's needed from initially first from the policymakers and the legislatures, so that oversight bodies at the EU level, the European Data Protection Board, the European Data Protection Supervisor, but then national data protection authorities and other related oversight authorities, they need that clear and precise legislation that Professor Saul mentioned earlier on to regulate and govern these systems in order to then provide their guidance in terms of compliance and monitoring. So the legislative cycle here is a very delicate one. And as Helen also highlighted, there is, in addition, the impact of the rapid development of the technology, and that can, it's I mean, as Helen rightly pointed out, this isn't a novel development for policymakers in the digital space, but the pace at which this disruption now can happen because of technologies, be it generative AI and ChatGPT, and the surfacing of agentic AI coming to the fore this week, it is a source of further disruption and uncertainty in terms of how these developments are engaged with. But I think Helen was quite right to mention that there are existing mechanisms, there are co-regulatory measures in terms of having the advisory boards and relying on an ongoing dialogue with relevant experts, not just in law, but in other fields. And that's incredibly important in terms of the horizon scanning that Helen and other experts in the scientific field, such as Jeffrey Hinton, have mentioned. And I think also the reference to AGI is a very important one in terms of general intelligence. There seem to be very split schools of thought in terms of how to address that now in legislation and governance. From a scientific perspective, there are those that will tell you it's around the corner in a few years' time. There are others that say we're nowhere near AGI for 70 years. And then there are those that will make the argument that, but that doesn't mean we shouldn't be considering the implications for society it will pose and to various sectors in terms of thinking about the precautionary principle and societal impacts and human rights. So thank you so much, Helen. That really was quite an impressive, rich overview of a very timely and ongoing topic. So from Australia to South Africa and Europe, we now move on to the North American section of our panel. And again, I feel as if I must extend my apologies to Stefan before I introduce him again, the Assistant Commissioner for the Information and Privacy Commission of Ontario. Stefan, you are very welcome once more, and we look forward to your intervention now whenever you are ready to join us. Thank you.
Thank you. Good afternoon.
So Stefan, we can't see you. So Stefan, we're having trouble with seeing you and with your audio currently, just so you know. Okay, now we can see you. Wonderful. You're currently frozen at the moment. It may help to
He's
turn.
been kicked out.
Okay.
He's gone.
Okay, so yeah, that's probably the best thing to do. Rejoin in a situation like that. That's usually my first port of call. While Stefan is just addressing that connection issue, we shall move on to our next speaker on the panel, also in our North American section, just while we're waiting for Stefan to rejoin us. I hope that's okay with you, Alex. Wonderful. Okay, so I'm very excited to introduce you to Alexander Amack McGilfrey. Alexander was Deputy Assistant to the US President and Principal Deputy United States Chief Technology Officer in the Biden administration. He held a similar role also in the previous Obama administration. Alexander helped found the Trust and Safety Foundation and the Trust and Safety Professional Association. In previous posts, he was also General Counsel of Twitter and Deputy General Counsel at Google, where he created the Product Counsel position. Alex, you are very welcome, and please begin whenever you are ready. Thank you.
Sounds good. Thank you, Nora, and thank you to the Institute for Advanced Legal Studies. I've really enjoyed the previous session, so I'm excited to be part of this august panel and looking forward to hearing from Stefan as soon as I'm done. I'm going to try to do a couple of things if I have the time, that is. First of all, I'm going to talk a little bit about the Biden administration AI policy, then what happened next, as well as this is going to include some news that is really real time today. And then if I have time, I'm going to try to ask some questions about things in terms of development of the technology that we don't know the answer to and that are important to regulation both in the US and worldwide and that haven't been discussed yet at the conference. So hopefully I'll have time for all of those things. But first, in terms of the stuff I have firsthand experience with in terms of the Biden administration, our approach was really trying to intelligently regulate AI because we thought it was important both to innovation and for human rights. There were real harms that we could see happening right at that moment, but we also knew that there were future risks and opportunities. So that was sort of the mindset that we had. We were thinking about it very much from an executive branch perspective. That's because Congress didn't seem like it was going to do anything with respect to AI and still hasn't done anything with respect to AI in the US. So the executive branch tools, there are really a panoply of tools, and I'll talk about a bunch of them, but let me just enumerate them. There's the bully pulpit, there is government spending, there are voluntary codes of conduct, there are standards, executive orders, enforcement of existing regulations, export control, and procurement regulation. So there's all of this different stuff you can do as an executive branch to do regulation, oversight, and enforcement. One of the things that we really started with was the blueprint for an AI Bill of Rights. This was before ChatGPT came out, and I was lucky enough to be a co-author on the blueprint with Dr. Alondra Nelson, Dr. Suresh Venkata Subramanian, and Dr. Sorel Friedler, as well as a bunch of other great folks. But this really was squarely in the bully pulpit. It was not enforceable regulation, but was instead a guide for what the administration thought was the right approach with respect to rights impacting AI. And it basically laid out 5 different things that we wanted from that. One was that it would be safe and effective. Too often, effectiveness is actually overlooked. There's plenty of AI out there that's just bad for purpose. That it be non-discriminatory, that it be privacy protective, that it have notice and explanation. Notice that an AI technology is being used, and explanation of the things that are happening within the AI to come to a decision. And that there finally be human alternatives, consideration, and fallback. So that's sort of what the blueprint for an AI Bill of Rights was trying to push forward. Also, on the launch of the blueprint, we coordinated with the various enforcement agencies to make sure that there would be an enforcement strategy with respect to current law. The enforcement agency heads said, and I quote, "There is no AI exemption from the laws on the books." And that's really important. In the US, there is a ton of law already on the books, and all of that already applies to AI, even as it is written today, with nothing else touching it. As I said before, the AI Bill of Rights was non-binding, which has its drawbacks, of course, but also meant that we could be a little bit more forward-leaning than if we were trying to come up with a binding process. We probably wouldn't have been successful coming up with a binding process at that time, but also it would have been something that would have been much less forward-leaning. Another thing to highlight there was the National AI Research Resource. This is an idea of building federal infrastructure, public infrastructure for public AI experimentation and use. The NAIR, the National AI Research Institute, is research resource. Is something that's still ongoing. The Commerce Department came out with standards through its standards body, NIST, the AI Risk Management Framework, and later created the AI Safety Institute. We did a convening of the AI CEOs to get voluntary commitments. This is another thing that I think is underutilized, but can be quite useful. Again, it's non-binding, but it is extremely effective at moving quickly and getting commitments from industry. Those commitments can then be used as a floor for regulation in the future. The Biden administration, we successfully got red teaming, AI bug bounties, audio and video watermarking, model capabilities and limitations, and an attempt to push the companies to do more in terms of using AI for the public good. Again, that's not going to take the place of enforceable regulation, but it was an important step as this technology is moving quite quickly. There was an executive order, and the executive order is worth talking about. It was completely voided by the Trump administration, but it's worth talking about because I think it really encapsulates some of the tensions in AI regulation all over the world. And in particular, there's this tension between benefits and harms, and then between existential risks and current harms. The existential risks, what happens if AGI all of a sudden takes over the whole world, turns us all into paperclips? That is certainly something that a lot of people are thinking about and that governments are trying to regulate in. But then there's also the current harms. We heard earlier about the bias inherent in AI, the risk to privacy, the risk to children in terms of taking them off on paths towards suicide. These are things that are actually happening today. And the balancing between dealing with the existential risks and dealing with the current harms was something that you could see in that executive order and is something that you see in almost all AI regulation today. There was a major focus on the to-dos, the actions of government. This is also like how much are we in the process of regulating government versus how much are we trying to do public policy and regulate industry or the public at large. Those types of tensions are things that I still see in a lot of things today. The last thing I talked about in the Biden administration was something that got a lot less coverage, but in my opinion is extremely important, which is it's called a management memo. This is a memo from the government to the government, telling the government how to deal with AI. And this is something that is still ongoing. The Trump administration did change it, but it is something that is still making a difference, creating specific officers within government to be responsible for AI, and then making sure that those agencies review and get their systems into compliance with government mandates over time. And again, that's something that Trump has not has changed a little bit, but is still, the core of it is still there. That will be something that, to the extent we have a change back to the earlier responsible innovation type of approach, it will be a very useful thing to build on. So what happened next? Well, the Trump administration pushed back a bunch on what the Biden administration did. They got rid of the executive order. They really changed from a responsible innovation approach to a win-at-all-costs approach, with a side of making sure that AI isn't woke. That seems to be a particular fetish of the Trump administration, is trying to really focus in on that, irrespective of other harms or consequences. And that meant executive orders that were attempts to remove regulation on data center construction and otherwise pour more gasoline on the AI industry fire. It also meant that export regulations seemed to change when a foreign state, in this case the Saudis, invested money through a Trump family cryptocurrency. So you do have a pretty fluid and somewhat transactional AI policy, which was not really the case in the Biden administration. At the same time, and still no federal action on AI. At the same time, the states have been extremely busy in this area. Every state, including the District of Columbia, Puerto Rico, and the Virgin Islands, is considering some form of AI legislation. California is out in front with model builder disclosures of safety frameworks and critical incidents, as well as whistleblower protections, getting to one of the questions in the chat. New York has a management letter-like law for state AI use. Arkansas has a law on AI content ownership. And there's lots of sector-specific stuff, from use of AI in hiring to multiple states concerned about film and stage actors' rights against appropriations by AI, AI in licensed professions, AI for political ads or races, AI in child pornography or broader child protection, AI in privacy. There is just a ton going on in the states. Supreme Court Justice Louise Brandeis once described our federal system as being important that a single courageous state may, if its citizens choose, serve as a laboratory and try novel social and economic experiments without risk to the rest of the country. In AI, this is happening like gangbusters. The laboratories are churning away. But this is the rapidly developing part. The Trump administration is getting grumpy about all this state action, and is just about to issue, rumor is that they will issue today or maybe early next week, a executive order that aims to curtail the state action by restricting unrelated funding, and also by suing individual states, as well as proposing a federal law to preempt state law. But that will be just a federal placeholder law in order to spur fewer regulations on AI. And that could all come out as soon as today or as late as early next week. So if I have a couple more seconds, does that seem okay? Great. So if I have a couple more seconds, I think what gets unsaid is how much we don't know as regulators, and as an industry, the industry doesn't know, that is really important to regulation. And I'm going to talk about a few things here. First of all, we don't know how good AI gets, and that really makes a big difference towards regulation. Are we dealing with something that could be as smart as being able to understand law and abide by it? Are we dealing with something that could take on humans? Are we dealing with the AGI type super intelligence explosion? Or is this just normal technology? And that'll be important. We won't know it for quite some time. And really, nobody knows that. And it really matters as to how aligned we can get it towards our rule sets. How feasible or realistic is introspection or explainability? We always talk about trying to understand why a particular action is being taken. Right now, we don't have a good understanding of what's actually going on within these black boxes. Lots of scientists are working on making observability and explainability a real thing in AI, but we really don't know whether we will be successful in that or not. And that could have a tremendous impact in how we write regulation and how we commit oversight to these AI systems. How many frontier models will there be, and how competitive will the open models be? This is really a question of, like, is there an AI race to be won? Will there be one model that we're dealing with? Will there be a set of models? Is this like nuclear power, where there will be a certain number of nuclear power plants in the world, but a finite number that we could go in and regulate one by one? Or is this more like encryption, where models will be everywhere and it will be really hard to do some top-down regulation within the model space, just because different people might be using different models in a way that makes it harder for them to be regulated? We also don't know how useful smaller models will be. Right now, it takes a lot of infrastructure to run, certainly to train one of these big models, but also just to run and do inference against these big models. We don't know the answer to any of these questions, and it's not just regulators that don't know the answer, but the industry itself doesn't know the answer, which is not to say that we shouldn't start regulating and that we shouldn't think about how to regulate these things. Regulating under uncertainty with technology happens all the time, but it does mean that we should be humble in how we think about what we know about the future, and that our regulation should be nimble and able to change as the facts on the ground change. Thank you.
Alex, thank you so much for a really fantastic overview of what have been really some seismic policy and governance changes at the US federal level in the past 10 years or so. It has been a shift in policy and governance that really the entire world has felt the implications of. And there are many observers, Alex, this week who have been making the very robust argument that the simplification agenda and these new proposals that Helen touched on just earlier to make the existing data protection law more targeted, particularly as it intersects with the EU AI Act, is in fact a response to the deregulatory turn as it is coming from the US at the federal level. And I think, you know, you raised some really important points that highlight what, you know, was a very different emerging AI governance landscape about 10 years ago, with that focus on AI safety and building capacity in terms of not just oversight, but also the early development of standards and multi-stakeholder collaboration between what's taking place in the private sector and getting those early commitments and that early engagement in terms of the initiatives being put forward by the private sector, a lot of the technological developments of which are intersecting with and then later subsequently impact on the drafting or revising of AI governance frameworks, as we're currently seeing under the AI Act, as Helen mentioned, in the European context. I think you brought up another very important point that also harks back to earlier points regarding legal uncertainty, that there is often a knowledge gap between the capacity of the existing technologies, emerging technologies for AI. And there's also that tension, we mentioned a number of very important tensions for policymakers about the fact that there is the lack of knowledge about the capacity of the systems, but also that raises the question of a lack of perhaps emphasis on the limitations of some of the existing automated decision-making systems for machine learning, you know, the contexts and spaces in which they've been developed in, and then perhaps their reapplication and appropriation in other sectors that they were never intended to be deployed in. And that's machine learning, automated decision making that we've been dealing with as policymakers, that oversight bodies have been dealing with for over 10 years in the US and elsewhere. But we see similar arguments coming up in terms of, well, how does that apply then to general models of AI in terms of how they may be reapplied in various sectors and various different applications? And yes, I think, there's some really interesting points you mentioned that are very relevant to the oversight and enforcement element for the legislative cycle for AI governance. The management memo, I must admit, I think I'm among quite a few academics that haven't engaged with that particular element of the AI blueprint as comprehensively as I should have, but I will definitely be prioritizing it more in future, Alex, because it focuses on an earlier point that was raised both by Professor Soul and also by Mukalani, which is developing that AI compliance capacity across government and also US agencies. So this touches on that point of resources, expanding the mandates of policymakers and oversight bodies. It means really nothing if they don't have the resources to carry out those functions, and that multi-stakeholder consultation that you talked about and being able to keep up to date with the technological developments. The resources element really is key. So I think, yes, that emphasis on building capacity and also sustaining it is just incredibly important. And, it's one of those back-end considerations that perhaps, really doesn't get, as you mentioned, the engagement that it deserves. But I think, yes, you've set the tone for globally the shift that we're now experiencing in terms of AI governance and regulation from a responsible AI approach, as you framed it, to a win at all costs approach. But again, that question of legal uncertainty and also the question of governance uncertainty and the political implications are so rife also, not just in Europe, but as you mentioned, in the US, a lot of this shift is happening at the federal level. But then, as you rightly highlighted, there are many initiatives at the state level where there is an emphasis on AI regulation. And you mentioned specifically significant developments in California. So it's fascinating to see the different divergences happening, even within the US itself, and how that's going to manifest, particularly perhaps in 3 to 4 years' time, Alex, when there may be another change perhaps in federal policy. I will stop myself there. Thank you so much for a really fantastic presentation, Alex. And if we just take a moment now to go back to Stefan and to see if you are ready to join us again, Stefan. And
I am here. Can you hear me and see me okay?
yes, you're
Excellent.
crystal clear and you sound crystal clear also. So, Stefan, the floor is yours whenever you're ready. Thank you.
Thank you. And maybe this all worked out for the best, because I will be giving a subnational provincial perspective to the panel. But thank you first of all for having me here today. And once again, I do want to pass on the regrets from Commissioner Kassim, who was unable to attend this morning or this afternoon, depending where you are. In my remarks, I'll touch briefly on AI in the broader Canadian context, but I do want to focus on the province and Ontario, a subnational sort of perspective for everybody here. And generally speaking, as governments adopt AI to deliver public services, we believe that maintaining public trust is essential. And earning and trusting trust requires clear parameters, including no-go zones, explanations of how AI is used, and a strong accountability measures. And then most importantly, meaningful engagement with communities. So in Canada, 2 years ago, the federal government tabled what was known as Bill C-27 that would have updated our federal cornerstone private sector privacy law, the Personal Information Protection and Electronic Documents Act, and introduced a new regulatory regime with respect to AI called the Artificial Intelligence and Data Act, or the ADA. This bill died on the order paper prior to the election that happened last year, and many hoped to see it reintroduced in the new parliamentary session. But since the Paris AI Summit, we are seeing a global shift in Canada and around the world, moving away from a safety first perspective towards market-driven, fast-paced AI innovation. Recently, our Prime Minister appointed Canada's first ever Minister of Artificial Intelligence and Digital Innovation. And in his first speech as Minister, Minister Solomon said Canada will move away from over-indexing on warnings and regulation to ensure the economy can fully benefit from AI innovation. It's still unclear for us how the government will strike the balance between advancing AI innovation and building trust through safe adoption. What form and direction the federal government will take on AI governance is uncertain. We do expect the federal government will likely move forward with privacy law reform, but all indications are that they will be dropping that ADA portion of the previous bill. So given this uncertainty, Ontario has a real opportunity to take the lead and set a model for an effective, innovative, and safe AI regulatory framework, particularly in the public sector. For those of you that aren't familiar with Ontario, we are Canada's most populous province with over 14 million people, and Ontario is currently building a world-leading hub of research, capacity, and investment in AI technologies. The Ontario government initiated the development of an AI governance strategy when it passed a bill last November called the Strengthening Cybersecurity and Building Trust in the Public Sector Act. And the first schedule of that legislation was called the Enhancing Digital Security and Trust Act, or EDSA as we call it, which empowered the government to regulate public sector entities with respect to mandatory cybersecurity programs, responsible use of AI technologies, and the use of digital technologies affecting children and youth under 18. Regarding AI specifically, the new law paves the way for future regulations to address transparency, accountability, risk management, technical standards, and oversight. But it also sets the foundation for establishing clear no-go zones that prohibit certain uses of AI technologies. Clear rules would provide legal certainty and predictability that public institutions need to innovate with confidence, while at the same time maintaining the trust of the people they serve. Although this is a relevant and timely law, our primary concern is that right now, EDSA is no more than an empty shell. Key protections, directives, and standards have been left to future, as yet undefined regulations, and almost a year has gone by since that law was passed. And until regulations are adopted, the law is basically ineffectual in guarding against potential misuse of AI. We advocated for a statutory framework for AI that is risk-based, codifies fundamental ethical principles, and provides for independent oversight. Unfortunately, we're still waiting for a meaningful AI regulatory regime. But that is not to say that AI is operating in a complete vacuum. Privacy and human rights laws still operate to govern the use of AI in our province. Our office and the Human Rights Commission of Ontario jointly called on the government to codify AI principles into binding regulatory framework, ensuring that AI is reliable and safe, valid, privacy protective, accountable, transparent, and human rights affirming. The Ontario government adopted a responsible use of AI directive to guide the use of AI systems by the public service, which now includes a set of principles that borrows heavily from our recommendations, which is great. However, this guidance is non-legally binding, very high level, and applies to only a small portion of Ontario's public sector. That is why we believe that we urgently need binding regulations under this act, and we need them to extend coverage over the broader public sector, including the health sector. The Human Rights Commission and our office continue to urge government to codify fundamental ethical principles guiding the development and deployment of AI systems by all public sector entities in Ontario in a manner that respects privacy rights amongst other human rights. Nationally, our office has also worked with regulators across Canada to help organizations developing, providing, or using generative AI to apply key privacy principles designed to mitigate risks. Together with Canada's federal, provincial, and territorial privacy regulators, we issued a document called the Principles for Responsible, Trustworthy, and Privacy Protective Generative AI Technologies in December of 23. And that was to advocate for clear and binding guardrails around the use of AI technologies. On the international front, our office co-sponsored 4 resolutions that were universally adopted at the Global Privacy Assembly in the past few years. These included resolutions on the collection, use, and disclosure of personal data to pre-train, train, and fine-tune AI models, a resolution on the meaningful human oversight of decisions involving AI systems, a resolution on generative AI systems, which emphasizes the AI systems must be based on principles of data protection, privacy, human control, transparency, and democratic values. And finally, a resolution on artificial intelligence and employment, which highlights important considerations for the use of AI technologies in the workplace. Meanwhile, as a regulator, we continue to receive complaints about the use of AI in our jurisdictions. And I would like to briefly highlight 2 illustrative cases. The first case was from last year, where we received a complaint about an Ontario University's use of exam proctoring software. The software was comprised of 2 different programs. The first was a program that locked down browsers and limited what users could access on their computers. And the second was a monitoring program which analyzed audio and video of students during the exam to scan for possible cheating. Our report into this matter at the end of our investigation concluded that conducting exams and appointing examiners is a lawfully authorized activity of the university, and proctoring exams online to ensure their integrity is an appropriate component of conducting certain types of exams and is also therefore lawfully authorized. On the question of whether collection of personal information through the use of proctoring software is necessary, we found that the lockdown browser program collected little personal information and only collected and used what is needed to function. The other monitoring program collected more sensitive personal information, including biometric information, and used artificial intelligence technology, which carried heightened concerns. Because of the personal information collected by this program on behalf of the university, it was necessary for that tool to fulfill its function of exam proctoring, and it was authorized under our legislation. However, the university had not provided adequate notice for its collection of personal information as was required by the legislation, and the use of students' personal information through the program was not in compliance with our act. Moreover, the contractual arrangement between the university and the company was contrary to the legislation insofar as it did not adequately protect all the personal information collected and allowed the company to use the personal information for system improvement purposes without the consent of the students. In the report, the Commissioner made a number of recommendations for the university to bring itself into compliance with the Act. And given the heightened risks associated with AI technologies, she also recommended that the university adopt additional guardrails around the use of the program and incorporate stronger protections into its ongoing use of the software and any future agreements with the company. I'll very quickly go over the second case, but it is in the healthcare sector where we see an increasing number of cases coming into our organization. In September of 2024, a virtual hepatology rounds meeting attended by a hospital physician was inadvertently recorded by an AI-powered transcription tool, Otter.ai. The physician had left his employment with the hospital in June of 2023, and he had installed this software on his personal device. And although the physician no longer worked for the hospital at the time of the breach, the tool was able to access the rounds meeting via the invite on the physician's personal, non-work regulated digital calendar because of 2 critical security gaps. First, the physician used his personal email address rather than a work address in the meeting group, contrary to the hospital policy. And second, the meeting organizer did not remove the physician from the meeting invite following his departure from the hospital. And as a result, the physician retained access to the meeting invite in his personal digital calendar for over a year after leaving the hospital. The tool was able to join the meeting or the rounds, I'm sorry, via the accessing the link and in the personal email calendar and recorded the meeting without notice. This was discovered when the meeting summary and the access to the transcript of the recording were automatically emailed to the participants after the meeting, including the account holder. During the meeting, the personal health information of several patients was discussed amongst the meeting participants and captured in the transcript. Upon discovering the breach, the hospital took the steps to contain the breach, notified the individuals, and implemented measures to further prevent breaches of this kind. Our office recommended additional measures, such as submitting a formal request to Otter.ai to delete the personal information of the patients, deleting hospital email accounts from other staff members, updating hospitals' privacy breach protocols and acceptable use policies, enforcing the use of a lobby for all virtual meetings where personal health information was discussed, amongst other recommendations. These cases are illustrative that we can no longer wait for government to act. That is why, together with the Ontario Human Rights Commission, we plan to release a joint principles for the responsible use of artificial intelligence systems. The principles flesh out our organization's expectations with respect to the use of AI and provide Ontarians with a more concrete understanding of what is expected in AI systems deployed by institutions. We'll also be releasing more specific guidance on the use of AI scribes in the healthcare sector in the coming months. The idea is not to inhibit AI innovation, but to support its responsible deployment. Our office's commitment to Ontarians remains steadfast, and we will continue to focus our efforts on enabling ethical use of AI that protects the access and privacy rights of our constituents now and in the future. Thank you, everybody.
Stefan, thanks so much for really fitting in thematically so well to a lot of the points raised by Alex in terms of the tensions of what takes place at the federal level, state level, to then at the provincial level, and then also at the municipal level as well, and where that leaves regulators, even very influential regulators like yourself that have been able to advocate and had the resources to be so engaged with the AI policy debate in Canada and also internationally at the Global Privacy Assembly and contributing to those very important resolutions. There's a tension there and, you know, a huge challenge for oversight bodies, depending also on those various levels of where they find themselves situated. And that is a really, really significant point in that one size doesn't fit all in terms of improving conditions for oversight and monitoring bodies for AI regulation. Very much depends on your role, provincial, federal, municipal, and also in terms of the case samples that you gave, so much also depends on your relationship as a regulator with internal compliance data protection officers or the data management officers in education, in health. It's an incredibly complex framework to be operating in. And as Helen Dixon was highlighting earlier on, that's compounded by the pace of technology, the pace of political change, and then those gaps, as you mentioned, in the legislative regime that obviously you will push for in terms of one of your many responsibilities in your mandate in terms of raising awareness and having greater legal certainty, pushing for binding AI regulation across the wider public sector in specific sectors, but then also being in that position where you can't stop functioning because you don't have that framework. So then being able to play a role in providing at least guidance, even if it is non-binding, so that it's there, it's providing some certainty to public sector bodies and to other private sector authorities as well. And I think, you know, your points are well made too regarding the emphasis on public trust that needs to be there for the guidance, for the information to reassure the public about the AI systems, how you're approaching them, whether it's non-binding guidance or whether it's binding guidance. I thought the point you brought up too, which hasn't been There's been so much covered over the past 2 days, Stefan, but actually outright bans on AI practices or no-go zones hasn't been an area I think explored as much as perhaps we should be exploring. It's one of those regulatory tools at the hard end of regulatory enforcement, having those hard bans. So I think really important to raise that debate about the role of no-go zones and how they should apply and where they should be applied. So Stefan, thank you so much. That was incredibly rich and gave, such important perspectives and insights from all those different policy levels that we mentioned. So wherever this finds you in the world, thank you so much for joining us. I'm wishing you a very good rest of day or a pleasant evening, and I hope you can join us for the Centre's next programme of events in 2026. So thank you so much, everyone, and have a good rest of day.